Hi, my name is Zulana Minti Amir and my metric number is 301330. I will explain the type of guarantee discussed in this case, which is a joint and several guarantees. This case is a clear illustration of how guarantees function in banking and commercial transactions and why they are considered such powerful tools for lenders. In this case, the guarantors accept liability as a principal debtors, not merely as sureties. This distinction matters because a surety liability is secondary, arising only after the borrower has been pursued. Here, however, the guarantor's liability was primary and independent, meaning the bank could proceed directly against them when the borrower defaulted. This gave the bank immediate right of recovery and placed the guarantors in the same position as the borrower itself, strengthening the lender's position considerably. Joint and several liability also mean that each guarantor was responsible for the entire debt, not just a portion. The bank had the right to recover the full outstanding amount from any guarantor individually or from all collectively. The guarantors could not demand apportionment of liability or insist that the bank acts against the borrower first. The court confirmed this, making the lender position very strong and minimizing the risk of non-recovery. This explains why joint and several guarantees are widely used in banking, as they maximize security for lenders and ensure repayment is more certain. The guarantees were also continuing, which means they did not only cover the initial loan facility, but also future liabilities arising from renewals, extension, or modification. Guarantors were not discharged by amendments to the facility agreements, change in interest rate, or extension of time. Even variations in the ECOF rate made without their consent remain binding. The court upheld this, showing how continuing guarantees ensure lenders' rights remain intact even when the loan term evolves. In addition, the guarantee was absolute and unconditional. The guarantor's liability was unaffected by whether the bank enforced securities, appointed a receiver, or granted indulgence to the borrower. The guarantee even included a clause that a certificate indebtedness issued by the bank would be conclusive evidence of the amount due unless a manifest error was proven. The defendant's denial were insufficient, and the court accepted the certificate as a valid proof of debt. Finally, the court concluded that the guarantees were valid, binding, and enforceable with no triable defense available. This case demonstrates the strength of joint and several guarantees, especially when combined with principal debtors, continuing, and unconditional clauses. It also highlights the importance of guarantors fully understanding their obligations before signing, because once agreed, courts are reluctant to intervene with a clear commercial contracts.
Hi, my name is Sofia Fatiha binti Kamar Zaman with metric number 301269. So now I will explain the issues that are raised by the defendants in this case. Firstly, the defendant argued that the plaintiff had varied the ECOF, which is effective cost of funds. They claimed that these changes to the interest rate were made without their knowledge or consent. According to the defendants, this unilateral variation materially affected to the loan facility and therefore should discharge or at least reduce their liability as a guarantors. Secondly, the defendants contended that the plaintiff failed to exhaust its remedies against the borrower. They argued that the plaintiff should have first taken legal action against the borrower company and enforced other available securities, such as assets that placed under the receivership. The defendant maintained that a guarantor's liability is secondary in nature, and therefore the bank should not proceed against them. Thirdly, the defendant disputed the amount claimed by the plaintiff. They challenged the quantum of indebtedness and alleged that the interest calculation was unclear. In particular, they argued that the ECOF rate was improperly applied. However, they did not provide any supporting evidence or alternative calculation to substantiate this claim. Next, which is the last one, the defendants attempted to argue that they were merely guarantors or sureties and not a principal debtors. By raising this issue, they sought protection under traditional principle of suretyship, where there is liability only arise after the creditor has taken action against the principal debtor.
Assalamualaikum, my name is Nur Fatina Ziva, Matching number is 301322. Today I will present the answer of question 3. Does the plaintiff have the right to enforce the guarantee provided by defendants due to the loan facility being default? In this case, the main issue is whether the plaintiff Bank Pembangunan Malaysia Berhad has the legal right to enforce the guarantee provided by the defendant after borrower default on the loan facilities. The borrower had obtained 2 loan facilities from the plaintiff to finance an industrial manufacturing project. As part of the security for this loan, the defendant executed joint and several guarantee agreement in favor of the plaintiff. However, the borrower later failed to comply with the repayment obligation, resulting in a serious default. By January 2017, the outstanding amount has exceeded 128 million. Under contract law, a contract of guarantee is an agreement where a third party, known as the guarantor, promises to be responsible for debt if the principal debtor fails to perform his obligation. Importantly, where the guarantee states that the guarantor is liable is a principal debtor, the creditor is entitled to take direct legal action against the guarantor without first suing the borrower. This principle is well established in banking and commercial transactions. In this case, the guarantee were clearly draft, proper, execute, and legally valid. The express state that the defendant liability was joint, several, and continuing. The guarantees also provide that the defendant's obligation would not be affected by any variation, renewal, amendment of the loan facility, even if such change were made without guarantor's knowledge. After the borrower default, the plaintiff issued notice of demand and termination to both borrower and defendants. At that time, no objection were raised regarding the existence of the debt or default. The defendant later argued that the plaintiff should have first enforced other security or pursue remedies against the borrower. However, the court rejected this argument, holding that the guarantees were independent securities and the plaintiff had made the right to choose enforcement strategy. As no terrible issue were raised and the guarantee were enforceable, the court concluded that the borrower default had given the plaintiff a clear legal right to enforce the guarantees. Consequently, summary judgment was granted in favor of the plaintiff, allowing recovery of the outstanding debt directly from the defendants. That's all. Thank you. To answer the question in question 4, the main issues in this case is whether the defendants as guarantors have the right to contend against the plaintiff for failing to inform them of changes in the interest eco rate which they claim were made without their knowledge or consent. The plaintiff is Bank Pembangunan Malaysia Berhad, while the defendant are Ibu Kota Realty Sendirian Berhad and Loh Chia Hong, who stood as guarantors for the loan facilities granted by the bank. The plaintiff applied for summary judgment under Order 14 of the Rules of Court 2012 on the basis that there were no tribal issues. The defendant argued that they should not be liable because they were not informed of the changes in the eco rate and did not consent to such changes. However, the court held that the defendant do not have a valid right to contend against the plaintiff. This is because the facility agreements expressly gave the plaintiff bank the contractual right to vary the interest rate, and there is no legal requirement for the bank to obtain the guarantor's consent or to separately notify them of such variations. Furthermore, the guarantee documents clearly stated that the defendant were liable as principal debtors and that their liability would not be affected, discharged, or reduced by any variation or amendment to the facility terms, whether such changes were made with or without their knowledge or consent, as the defendants were not parties to the facility agreements, they had no standing to challenge the bank's contractual right under those agreements. The court also accepted the plaintiff's statement of account as conclusive evidence of the amount due, as no manifest error was proven by the defendants. The defendants merely raised bare denials and failed to show any triable issues. As a result, the court granted summary judgment in favor of the plaintiff, holding that the defendants remain fully bound by the guarantees despite not being informed of the interest rate changes.
Hi, doctor. My name is Chin Tek and my entry number 297-823. Now, I would like to continue to explain the difference between dependent 1 and dependent 2 as a guarantor and their liability as principal debtors. First, for dependent 1, which is Ibu Kota Realty Sdn Bhd, enter into the guarantee documents in terms that the company jointly and severally labor with the borrower. Well, for dependent 2, which is Law Chat Hong, has executed personal guarantee in favor of the bank. Ibu Kota Realty labeled as a principal debtor to being a guarantor, meaning that its liability is equivalent to borrower, while Law Chat Hong would be treated as a principal debtor, not merely a secondary surety. While for the bank side, the bank may proceed directly for the full outstanding sum without pursuing to Ibu Kota Realty, while the bank may likewise sue directly for the full outstanding amounts to Law Chat Hong. Next, Ibu Kota Realty has jointly and severally labelled with the borrower and any co-guarantors, while for Law Chat Hong, liability as principal debtor places him on the same footing as borrower. Last, independence for the guarantee. Liability continues even if there are disputes between the bank and borrower in Ibu Kota Realty, while liability is absolute and unconditional and not dependent on action against the borrower for Lord Chat Hong. Lastly, as a conclusion, although one of the guarantors was a company and the other is a person, both of them become primary debtors to a respective document. This means that both were jointly and wholly liable to the debt of the borrower, and the bank was not limited to seek to enforce it against the borrower first, and then proceed to file a lawsuit against them. That's all for our group. Thank you.